Welcome to the second webinar of the 2021 Year in Review series. Today's topic is employment litigation. Fasken's National Labour Employment and Human Rights Group will be hosting additional webinars in this series on November 16th and 23rd. To register for either of those webinars or to view the recording from last week's webinar on the federal sector, please visit the Fasken Institute section of our fasken.com website. My name is Karen Sargeant. I am a co-leader of Fasken's National Labour Employment and Human Rights Group. I'm also a partner in our Toronto office and chair of the Ontario Labour Employment and Human Rights Group. I have with me today three colleagues. The first is Magali Cournoyer-Proulx. She is a partner in our Montreal office, and she is co-chair of the Quebec Labour Employment and Human Rights Group. I also have with me Elizabeth Reid. Elizabeth is a partner in our Vancouver Labour and Employment Group. We are delighted to have her. She joined us within the last year, and she's been a great addition to our team. And then last but not least, we have Maria-Cristina Cavicchia with us. Maria is an associate in our Toronto group. I say not least because Maria was really responsible for corralling the three partners and putting this presentation together. Maria has been practicing for just over a year now, and I think, as you'll see in this presentation, has already demonstrated superstar capabilities in this area. So delighted to be presenting with these three women. Before we begin, I have a few housekeeping notes. First, there is an online survey. At the end of the webinar, if you have time, please click the survey button underneath the video window, and this survey will help us determine future topics, and we always appreciate your input. Second, the materials for today's webinar can be accessed via the materials button, also under the video window. We are also recording today's presentation, and the recording and the materials will be distributed to you by email within the next week or two. Questions. If you have questions, please submit your question via the chat box. We will do our best to answer as many questions as we can at the end of the presentation, and Maria will facilitate that question and answer session. We also are pleased to report that we have closed captioning feature now on our presentation. If you would like to turn on this feature, please use the CC button in the bottom of the video window. Technical support. If you need it, please click the tech support button and one of our techs will help you out. And if you, like so many others, are looking for COVID-19 specific information, we will obviously discuss some of it today, but if you're looking for other COVID information, we have a wealth of information in our COVID-19 Knowledge Center, which can also be found at fasken.com. So with that, we'll start our presentation. So what we've done is we've divided our presentation into the new and the normal. The new, we'll be talking about items that have come out of the COVID-19 pandemic. And this really struck me because when we did this presentation last year, at that point I thought we really should steer clear of COVID-19 related matters because we were all sick of hearing about it. So I can't believe here we are a year later and COVID-19 is still such an important part of our workplaces. So we'll start with that. And then we will also talk about the normal, because while COVID-19 has been happening, regular employment law has continued to develop. And so we want to capture that portion of the case law in the normal part of the presentation. So first we're going to start with the new, and we will start with Magali, who's going to talk about what is on everyone's mind, mandatory vaccination policies. Over to you, Magali.
Thanks, Karen. So as you said, it's true that last year we talked a lot about COVID and thought that that would be it. And we were talking about the same sort of subjects, safety measures, testing, absenteeism, remote work. But the new about COVID now is what 2021 brought along, which is the vaccination. And so the new that we're going to be discussing briefly, because we have many, many topics to talk about today, will be the vaccination policy. This has brought certainly new issues, new challenges for employers, but we are seeing that these policies are being developed, implemented, and applied throughout the country. And obviously what employers are trying to do on the one hand is to protect the rights of individual workers, but on the other hand, to ensure that they meet their health and safety obligations towards their staff, their clients, and the public in general. And so the first issue that employers had to deal with was whether they could put in place a vaccination policy. And certainly, I think that the health authorities have supported that in those initiatives in many provinces. The health authorities have actually recommended or imposed that such policies be put in place. And the next issue was, what should they cover and to what extent can we put in place a vaccination policy? And so what can it cover? And should it be only applied to employers that have employees on site where remote work is not possible? Or can we impose vaccination policies within those companies where employers want to bring back their staff into the offices? And I believe that those are both certainly legitimate objectives. I think it's within management rights for an employer to want to bring back their staff, especially now that we know that the vast majority of the population is vaccinated. So in doing that and wanting to bring back their staff into offices, certainly employers want to reassure their employees, ensure the health and safety of those employees and their clients, and as we said, the public in general are protected. So now that we know we have policies in place, we know what they can cover, now it's how do we deal with employees who refuse to be vaccinated? And when these reasons would be for medical reasons, which would apply to only very, very few and rare circumstances, well, then I think it was made clear that there's a duty to accommodate those exceptional circumstances. But when the employee refuses to be vaccinated for personal reasons, there's no duty to accommodate on employers. So what do we do with those employees? Should we put them on an unpaid leave of absence? What will happen if we actually cannot put them on an unpaid leave of absence because we need to hire someone else to do the job? Can we terminate them? And if so, will they be ultimately owed compensation? So these are the questions that we're dealing with on a regular basis. Certainly, the tribunals will be asked within the next few weeks and months to deal with those situations. I know there's a Quebec decision that is expected to be rendered in mid-November about an accelerated grievance on this type of topic. So we're expecting some decisions to come along very quickly. In the meanwhile, what we know is the federal government established some guidelines with respect to employment insurance program. And these guidelines confirm that employers, indirectly confirm that employers have a right to dismiss employees who do refuse to be vaccinated, not in all circumstances, but in some. And when I say that, it's when we read through their guidelines, and they're easily accessible on the website of the Ministry of Employment and Social Development Canada. And they talk about the new codes that the employers can use to indicate the reason for an employee's leave or separation from employment. And so in the traditional circumstances that we've seen in the last year, when the employee was no longer working because the business had decreased operations or closed due to COVID, employers were asked to use the code A, which is for shortage of work. And when the employee was sick or quarantined, employers had to use the code D for illness or injury. But now the ministry had also provided guidance on how to guide employees on an ROE, how to code employees on an ROE when they have not complied with a mandatory vaccination policy. And so what the ministry advised to do is that if the employee doesn't report to work because they refuse to comply with mandatory COVID vaccination policy. And I think, we're on the, so if if the employee doesn't report to work because they refuse to comply with a policy, then employers should use the word the code quit or the code leave of absence. But if the employer suspends or terminates the employee who has not complied with the vaccination policy, then the code dismissal should be used. And what the ministry also added, I think is very interesting, is that if these codes are used, employers will be or may be called to ask and inquire about additional circumstances. And the 4 types of items that will be looked at are the following. So the first one will be whether and we can switch, thanks. So the first thing that it will look at is whether the employer adopted and clearly communicated to all employees the vaccination policy. Number 2, whether the employee were informed that failure to comply with the policy would result in loss of employment. Number 3, whether the employer applied the policy in a reasonable fashion within the workplace context. And number 4, whether it allowed any exemptions for employees refusing to comply with the policy. And I think those 4 criteria can easily be looked at from another perspective, which is the enforceability of the vaccination policy and ultimately the right of an employer to dismiss an employee for not complying with that policy. And I'm sure that a judge, a court, an arbitrator would likely also look at those 4 questions or 4 items and try to see whether the employer has followed these steps. And the test of the reasonableness and how it was applied and why it was applied and whether there were some interim possibilities like putting the employee, like we said earlier, on an unpaid leave of absence instead of proceeding right away to the dismissal. All of that may be looked at by a court before determining if a dismissal was made for cause or not. So the key takeaways for employers, I think, when looking at those guidelines from the ministry is that an employee's refusal to be vaccinated when vaccination is a condition of employment could certainly result in a denial of EI benefits. And I think too, with a justification of a termination for cause. And, it'll be certainly interesting, like I said, to look at how the courts deal with those first challenges as they're being brought up. But what we have seen in the past months or so is that clearly there's some early signs from tribunals and also health authorities to suggest that when balancing safety versus individual concerns, safety vaccine mandates generally takes priority. And so in the next PowerPoint, we have 3 examples of these types of early litigations that seem to show support for mandatory vaccines. The first one was at the end of September in Saskatchewan. There's an application filed to argue that the province's vaccination policy was in violation of charter rights. The applicants were trying to obtain an injunction relief and bar the proof of vaccine requirements that applied to people going to some indoor restaurants, theaters, etc. And the court decided to side with the respondents who had argued that the injunction proceedings were fundamentally flawed because we could not establish, or they could not establish any proof that the vaccine requirements could cause irreparable harm, which is necessary in injunction proceedings. The second example was a case dealt by the Human Rights Tribunal in British Columbia. And in this case, the complainant had filed a complaint against the provincial health officer alleging that the new order requiring proof of vaccination to access certain services constituted discrimination in services on the basis of disability under the Human Rights Act. The person or the complainant had tried to argue that he had asthma, had pneumonia as a child, and did not want to experimental the COVID vaccine. And the BC Human Rights dismissed at the preliminary stage the complaint, judging that there was not enough proof to sustain that the alleged disability was connected to the adverse effect, such as the disability prevented him from being vaccinated. And finally, a third example was there's a few case law, actually, more than a few, I think, now in Quebec that have recently, and I'm sure it's the same across Canada, that have recently ordered children that are 12 or over to be vaccinated in the context of parental disputes. And so the courts have judged that vaccinations is in the child's best interest. So those, I think, are permitting us to be a little more optimistic in terms of how the courts will deal with those challenges being brought up by employees that are being terminated in a context where the employer has used reasonably its management right to implement, develop, and apply those mandatory vaccination policy. I will now turn it to Karen, who will talk about another recent decision in Ontario on that topic.
Great, thanks, Magali. One thing I'll say before I get to this decision, like Magali said, we are dealing with these questions all day, every day. And one thing I do say to employers is, remember, it may not be a one size fits all. What might be cause to terminate in one organization might not be in another organization, or you may have cause to terminate folks who are not vaccinated in one type of employment situation, but not with respect to another category of employees. So it's still important, even as these cases come out, to still take an individualized approach when you're making these assessments. In any event, I wanted to talk about a case. We had a decision out of Ontario the week before last, and this was a case of Blake and the UHN. UHN is the University Health Network. It is a collection of hospitals and healthcare facilities in Toronto. And this was an application by a group of employees, both unionized and non-union employees. And they were seeking an injunction from the court to stop the implementation of the UHN's policy. So what was the UHN's policy? UHN's policy was that employees had to be fully vaccinated by October 22nd, 2021, or their employment would be terminated for cause. So the group of employees brought the application, hopefully seeking a court to say, look, employer, look, UHN, you can't terminate anybody who is not fully vaccinated despite your policy. At the first instance, the group of employees was successful. On October 22nd, the court ordered interim relief pending further argument, and did say that for a period of time, which turned out to be a week, UHN couldn't take any action in terminating any employees who were not vaccinated. Really, what the argument focused on was not the merits of a vaccine policy or whether employees failing to get vaccinated amounted to cause or not. What really was the argument is that the court lacked jurisdiction over the subject matter of the dispute. And the reason for that is that the legislature and courts have granted labor arbitrators exclusive jurisdiction over matters arising out of a collective agreement. And so the employer here argued that because labor arbitrators have jurisdiction to deal with matters of termination, not the court didn't have the jurisdiction to issue the injunction. The employer also made similar arguments with respect to the non-union employees, and said that ultimately in a wrongful dismissal matter, a court cannot force an employer to hire back an employee, and so therefore an injunction would not be appropriate. As I said, at the first instance, the court made an order preserving the status quo until further arguments could be made. Those further arguments were made on October 28th, and a decision was issued on October 29th. And in that decision, the court said that it would not award injunctive relief. So essentially, UHN could go ahead and apply its policy and terminate these employees. Now, what the court didn't do is the court didn't say that there would be cause if the UHN terminated employees. All the court essentially said was that the court didn't have jurisdiction to deal with the matter. With respect to the unionized employees, it said that because the essential character of the dispute lies squarely within the ambit of labor relations and the collective agreement, it was up to unions to proceed with this issue on behalf of their unionized employees before an arbitrator. And a labor arbitrator was fully capable of resolving these issues, and so therefore the court would not intervene. For the non-union employees, and this is where I thought was very interesting, essentially in order for an party to obtain injunctive relief, they must meet a test, a three-part test. There has to be a serious question to be tried. There must be irreparable harm if the order is not granted, and the granting of the order there must be a balance of convenience in terms of granting the order. And in this case, for the non-union employees, the court determined that there was no irreparable harm. Essentially, if a non-union employee was terminated for violating a mandatory vaccine policy, the recourse for the employee was through the regular wrongful dismissal process, where the remedy would be monetary damages, not reinstatement. And because the remedy wouldn't be reinstatement, there was no reason to award an injunction. So, as I said, this decision does permit UHN to continue implementing its policy. Whether or not ultimately UHN will be determined to have cause when it terminates some of these unvaccinated people is a matter that will get dealt with at a later date. But one thing that certainly we would assume would impact some of these decisions is whether there is a government mandate or not with respect to mandatory vaccine. And we know that in some provinces, there is a mandatory vaccine government mandate for the healthcare setting, for example. And in other provinces, there is not. Last week, the Ontario government, for example, said they were not going to mandate that hospital employees be vaccinated. So that is certainly one factor that could come into play when we see these decisions ultimately get tried on their merits. So back to you, Magali.
Thanks, Karen. So much to say. There's a lot to say about COVID. The next topic also has a link to the pandemic. So what we've seen, and we'll discuss three cases that dealt with the possibility of extending notice period due to COVID. And in the first one, the employee was actually dismissed a few months before the pandemic started at the end of August 2019. So the employee was 62 years old with 12 years of service, held a managerial position, had a high income, and he was claiming 18 months notice while the employer had offered him only 11 months. And one of the argument of plaintiff's counsel was that the pandemic should be taken into account and it should increase the notice period of the employee. Ultimately, the court decided to award 16 months notice and noted that length of service here, which was 12 years, was a neutral factor, but that the income, high income of $162,000, and the fact that he had been considered to be an executive of the company, both militated towards a longer notice period. However, with respect to the argument about the COVID pandemic, the judge decided to set it aside because the plaintiff had been terminated prior to COVID, and the judge was of the view that the economic conditions or situation that arose after the termination was not relevant because they were not in the employer's purview or could not have been considered at the time of dismissal. But the judge made some comments in obiter, so not binding, but did state that terminations that materialized during the COVID pandemic could result in an increased notice period because the employer would then have knowledge of the depressed economic conditions. And so when seeing that, I think that that was probably true at the beginning of the pandemic in 2019, but now that we see how things have evolved and how there is a lot of availabilities on the job market, especially for lower pay grades, salary employees. I'm actually using that against the employees when I go to mediation, and mediators tend to agree with me by saying that, yes, it's true that the job market there's so many jobs available for employees earning $25 an hour or a little more, and therefore it would be difficult for them to argue that the COVID pandemic should increase their notice period. Anyways, in the two other examples that I'll be discussing, the first one, the judge agreed to add an extra month because of the COVID pandemic. So here we had a specialized, this is the Kraft versus Firepower case. Here the plaintiff was a specialized commission salesperson in the investment banking industry. And he was specializing in mergers and acquisition, and he was terminated right in the second week of March. So just a day before the state of emergency began in Ontario, and obviously due to the markets, and he was working in the mergers and acquisitions at the time. It was everything was stopped, and so he sued the employer for 10 months notice plus commissions and bonuses. And the court agreed that he had made all the efforts to mitigate his losses, but it only granted and decided to grant him 10 months, which included that extra month I was telling you about because of the pandemic. The third case, Iriotakis versus Peninsula Employment Services. Here, the plaintiff was terminated at the end of March 2020. The plaintiff had received only 4 weeks of salary and benefits, but no payment with respect to his commissions earned prior to being terminated. He had worked only for basically 2 years with the company. He was 56 years old when he was terminated and was only able to secure new employment after 7 months. And the plaintiff was taking the position that he was entitled to at least 6 months due to the COVID situation. The court ultimately sided with the employer, saying that the plaintiff was entitled to 3 months notice period. The court agreed that the pandemic had some influence upon the plaintiff's job search, and that the uncertainties of the job market would serve to tell the period of reasonable notice in his favor. But then again, he said that his factors did not apply to the exclusion of the others, and that we also had to look at the other ones, and the balance approach was preferable. So in light of all the circumstances, the judge decided that 3 months was sufficient. But the other aspect of the decision that is interesting is that the employer was saying that the CERB benefits, the emergency benefits that were granted by the government during the COVID, should be taken into consideration to reduce any amounts that were paid to the employee. And as we know, the employment insurance benefits typically are never considered by the courts because there has to be like some reimbursement. And so the employer was pleading here that the CERB benefits were different from that perspective than EI benefits. And the court agreed that there are different types of benefits, but considering that the level of benefits, which was $2,000 a month, which much below the base salary earned by the plaintiff, and because the plaintiff had not been paid his commissions after he was terminated, well, on the balance of these facts, the court decided that it would not be equitable to reduce the entitlements from the employer due to those post-termination benefits he received from the government. So now we will go on and move on to another topic, and I will pass it on to Elizabeth, who will, well, there's certainly a link to the pandemic. She will discuss remote work issues.
All right, thank you very much, Magali. So when the pandemic started in 2020, the transition to remote work was abrupt. Businesses were basically in survival mode, and understandably, they weren't too concerned about the ergonomics of the couches that their employees were working from. However, remote work has continued into 2021, much to most of our chagrin, and businesses are now coming to terms with some of the complexities of having a remote workforce. Now, we could do an entire seminar on remote work alone. So for today, I'm going to keep things at a high level and just highlight some of the things that you need to be thinking about. Now, fundamentally, one of the big challenges with remote work is that it causes jurisdictional issues. About 85% of our Canadian workforce is provincially regulated. And each province has, unsurprisingly, its own different and special laws related to the workplace. So here are kind of four broad areas that I think you need to think about. The first is payroll. So your employees pay income tax based on the province that they live in. So this can create a bit of a mismatch if your payroll deductions are made based on the rules of a different jurisdiction, perhaps where your head office is located. You can either end up with a very happy employee who's getting a refund, or you end up with a very unhappy employee because they have a very large tax bill because not enough tax was taken off. On the employer side, the risk there is that by having employees in other jurisdictions, you may be creating what we call a permanent establishment in that jurisdiction. So, and the biggest risk there comes when you have a really senior employee who can, for example, enter into contracts on behalf of the company. Because the challenge with that is that once you have a permanent establishment, you're going to have an obligation to file corporate tax returns in that jurisdiction, which might be a headache that you were not anticipating and probably didn't want. A third kind of point on that front is that if employees are in the US or other countries, that's going to be even a bigger headache because all of a sudden you have perhaps a business operating in a completely foreign country with absolutely unknown rules and that doesn't kind of coordinate like we do here within Canada. The next area we need to think about in terms of remote work is health and safety. So an employer's occupational health and safety obligations, they just continue even if employee is working from home. So if your employees are moving into another jurisdiction, you need to determine whether the rules in that province are different and whether you need to register your business under the workers' compensation legislation where the employee is living. The kind of third and fourth areas to think about are employment standards and human rights. And it's the same basic problem. A change in jurisdiction means a change in the law. So this can affect your day-to-day. If you have an Alberta-based employee who usually gets overtime at 44 hours a week, and all of a sudden they're working from British Columbia where they hit overtime at 40 hours a week, you're going to have some unexpected labor costs there. The even bigger problem is with contractual termination clauses. A clause that works perfectly well to limit your contractual, your severance obligations in British Columbia may be completely, and in fact likely, is completely unenforceable in Ontario and is going to expose you to common law notice. Not something that most employers were anticipating when they said, sure, you can work from your family cottage in Ontario for 6 months. Now, just as employment standards are different in different provinces, the protected grounds under human rights law are also different as well. So, for example, in Alberta, you can refuse to hire someone if they have a criminal record, and the individual would have no recourse against the employer, in terms of human rights requirements. In Ontario, British Columbia, and some other jurisdictions, human rights laws require you to consider whether the conviction is related to the proposed employment. And if it's not, then deciding not to hire that person based on the criminal conviction could amount to discrimination. So essentially, again, we have this challenge of, different jurisdiction, different rules. So the key kind of takeaway from this slide is really know where your employees are at. Make sure you are tracking where they are working remotely from, and make sure you know the consequences of that move, particularly if they're moving into a different jurisdiction. So on to our next slide about remote work. Looking at some of the practical aspects of remote work, of course, we have privacy and security concerns. You need to think through the implications of having confidential information easily accessible outside your office and take steps to minimize those risks. Essentially, you're losing control of that information, particularly if the employee leaves your employment. Now, you can try to mitigate that through the use of policy and procedure, technology, much beyond my expertise, the technology part, but I hear you can do it, and contractual requirements as well. Another thing to think about is kind of consistency and equality, really sort of a morale issue, because many employees see permission to work from home as a perk. They see it as an indicator of the person's importance to the business or the trust that's placed in that individual. So making principled and consistent decisions about who gets to work from home and why, based on really objective factors like job functions, and communicating that to the staff so that they understand why certain people are allowed to work from home and other people aren't, that can help you sort of stave off some of those morale issues that can be associated with the work from home regime. And then who pays for what? We're already seeing cases about who pays for working from home. So it's really important to check what's permissible in your jurisdiction. There's a recent case in which the Toronto School Board faced a grievance from its teachers about expenses that they had incurred in the move from work from home. And essentially their policy saved them because the policy said that the teachers could make requests in advance if they needed to purchase something to work from home. So those who did so had a discussion with the employer, and they essentially agreed about whether the item was required, and if so, who was going to pay for it. Others who didn't follow the policy and then grieved because they weren't reimbursed were not successful in their claim. So again, a key reason to kind of think about these things and put something in place in advance. Another thing to think about is this working from home going to be a temporary change, or is it going to be a new contractual term? So in that respect, you need to think about what's best for your workplace and essentially make a decision. In this kind of case, permissiveness could end up with you having a new and perhaps unexpected contractual right for your employees to work from home. So do think about that. The last sort of category here I've got is sort of tracking time or overtime. And I categorize this under sort of policies and agreements generally. We really need to go through procedures and agreements and policies and see which ones are impacted if employees are working from home. There was one case in which I thought the union was being, frankly, a little bit cheeky because they claimed that callback provisions should apply even if the employees were working from home and didn't actually have to go back to the workplace if they got called back in. So essentially, your 5-minute call at home, which meant that you had to go from your couch to your kitchen table to talk to someone for 5 minutes, should result in 3 hours of pay. Now, the arbitrator did not think that was reasonable. The union lost on that case. They found that callback pay was really for the purpose of compensating you for having to go all the way back to the office. And if it just meant this little quick move to your kitchen table, that wasn't sufficient to trigger that obligation. So, but the key takeaway, I think, from all of these things is you don't want to get caught by surprise. You want to do the analysis and assess the risks in your particular business. And that is all we have time for on the work from home topic today. So I will turn it over to Maria to talk about an interesting class action case. Over to you, Maria.
Thanks very much, Elizabeth. So we'll take a brief break from all the COVID excitement, and I promise we will get back to all of the exciting COVID questions just at the end. But as Elizabeth said, I'm just going to provide an update on a recent class action decision. Frankly, it's one of the more interesting developments I found that have come out of employment law decisions and even just class action decisions over the last year. So in this case, an Ontario court certified a class of Uber drivers claiming that they had been misclassified as independent contractors, and they claimed that they were being denied employment benefits under the ESA as a result. Misclassification cases are things that we see most often in the courts when it comes to gig economy workers. Classification generally is a big issue in these decisions. And whether you're an employer or someone who's just interested in the gig economy, or you're in a workplace that's governed by certain types of contractual relationships that may give rise to these classification issues, this particular decision is definitely one to watch. It is lengthy, but I do think it's worth the read, and particularly for its input on the different types of classifications that are available. This is the latest saga between Uber and between these two particular parties. And really, again, the key issue is, are these individuals considered independent contractors? Are they employees? Or, as the court raised in this decision, could they be dependent contractors? And dependent contractors, of course, are not considered employees under the ESA or similar types of legislation, but they are the common law's middle ground. So recognizing that there are some entitlements these dependent contractors may be entitled to, but not as so far as employees would be. And again, this is a development to watch given the litigation history between the parties, and it's a good opportunity for employers to review their agreements for potential classification issues.
Okay, and that is back to me. So I'm going to talk a little bit about when is a quit really a quit. There's nothing too new in the law here, just a few cases reminding us that it's not always easy to tell when someone has quit. A couple of highlights. Generally speaking, a resignation needs to be clear and unequivocal. And we see in the three cases cited here that the courts are still kind of struggling with whether this should be determined on a completely objective basis or whether the employee's subjective intent also is something that should come into play. But I would say, practically speaking, if there's any uncertainty, that's likely to be resolved in favor of the employee. So it's sort of incumbent on the employer to take action and kind of initiative to resolve matters if you're in one of these kind of sticky situations where it's not totally clear on whether the person has quit or not. And that is particularly so if the employer knows that the employee is in difficult personal circumstances. For example, you're not hearing from them, but that they were on a medical leave, or you're not hearing from them, but that, in one case, their house burned down. So, in those kinds of circumstances, you can't just kind of jump to, oh, they quit. The other thing to kind of look for is when employees quit in a really highly emotional state. It's very dramatic, but it may not represent the employee's intentions. And the courts are going to give people a lot of leeway, particularly, if they kind of storm out, but then come back and say, look, I'm sorry, I didn't mean to, I didn't want to quit. So just keep those things in mind if you have one of those situations. The other thing is, don't forget to consider there are alternative arguments. So the employee may or may not have meant to quit, but depending on how they kind of did their quit or non-quit, they may have given the employer grounds to terminate without notice based on either repudiation of the contract or insubordination. And if you have those arguments available and there's a possibility that those might be successful, they end up having the same result as a quit in that the employee is not entitled to notice upon the end of that employment relationship. So that is all we have for you on quits and when a quit is really a quit. And I will turn it over to Magali to talk about individual acts of discrimination that can amount to termination for cause. Over to you, Magali.
Thanks, Elizabeth. Right. So termination for cause, as you may know, are very difficult to prove. So when a client calls us and says, I want to terminate for cause, it often turns out that we might want to still offer some kind of package to the employee because we know that they're very difficult to uphold, especially in certain circumstances, such as the one that we have here, where the employee had a very long service, occupied the highest position in the organization, and was aged 75 years old at the time of her dismissal. So, but in this context, a very particular context, the employer had gone through a very thorough investigation after being informed of various types of irregularities concerning this employee. And there were 15 areas actually of misconduct that supported the employer's decision to terminate the employment for cause of that employee. The employer did elaborate and make the proof of these 15 areas of misconduct, but at the end of his submissions, the employer focused actually on 6 of those areas of misconduct, and the employer was taking the position that these supported a finding that the trust in the employee was irremediably terminated, fractured. And some of those misconduct concern forging a document, taking unauthorized vacation, getting herself an unauthorized pay raise, awarding contracts to her sons without respecting the established protocols, obtaining reimbursement of charges made to her personal credit cards without supplying proper documentation. So from my perspective, all of these examples were quite, bad on the perspective of the employee, especially somebody who is holding such a high position in the organization. But the court viewed it differently when analyzing each assertion of misconduct in isolation. And for some of them, the court concluded that, yes, they were serious issues, some of them worthy of discipline, but that they were not enough in themselves. When looking at them each on their own, they were not enough to warrant immediate termination. So, for example, the court said that the employer could be rightfully disappointed in the fact that she taken vacation pay, but this was not misconduct from the point of view of the court. This was not misconduct that justified immediate termination for cause. Same thing about granting contracts to the sons. The court, based on the evidence that was showed to the court was not satisfied that these contracts had issue had any legs, and basically that it was much ado about nothing. So when looking at all of those individually, the court would not have granted, would not have concluded that the dismissal was made for cause. However, the court did take a step back after looking at each of them individually and consider the assertions on the whole and in the context of all of the other issues identified by the employer. And from that perspective, the court did feel that the termination was a result of the loss of faith and trust in the plaintiff to carry out her role of executive director within the Chamber of Commerce, and that loss of trust was basically the conclusion of an accumulation of a series of misconduct or an accumulation of various factors. And the court said that any one of the incidents of either malfeasance or poor judgment were not themselves sufficient to support a termination for cause, but taken together that they did. And therefore, just cause termination was warranted and did not require any types of prior warnings or progressive discipline. So when looking at this type of situation, I think what's very important when an employer uses many types of behavior is to list them properly in a letter of dismissal, and to make sure that the employer can take the position that on each of these various incidents may justify a dismissal for cause, but that also put all together that these would warrant dismissal for cause due to the fact that there has been a breach of trust that is no longer able to be repaired between the two between the employer and the employee. So I will now pass it on to Elizabeth, who will talk about bad faith and bad behavior.
All right, bad faith and bad behavior. This is always a fun topic. The first slide is kind of a reminder of what we're talking about there. Essentially, we're looking at claims or awards for aggravated or compensatory damages. So those claims usually involve conduct that is either untruthful, it's misleading, or it's unduly insensitive. It does require some evidence of the harm that has been done, not necessarily medical evidence, but evidence nonetheless. And the harm has to go beyond the ordinary hurt feelings experienced in any dismissal. I mean, courts are very aware that nobody likes getting terminated, so this is kind of got to have an aspect that goes beyond kind of those ordinary hurt feelings. On the punitive damages side, there we're really looking at not compensation for the plaintiff, but punishment of the defendant. Basically, the court saying we are not going to countenance this kind of behavior. It is, should be punished. So some of the trends that we're seeing with respect to kind of the bad faith and bad behavior claims, employers are being held to a very high standard of conduct. Some stuff that you might just think is sort of an administrative oversight, or, okay, maybe it was, not the most sensitive termination, but it didn't seem that bad. They really not having a lot of time for it. There's a lot of protection being given to employees. And the courts are quite prepared to look at behavior leading up to the dismissal, the actual termination meeting itself, or how the termination took place, and the period after the dismissal as well. And a thing to keep in mind is that your litigation strategy is relevant. And we have seen a number of cases where that has been held against the employer when they took a really strong position that the court ultimately found was unwarranted. So this isn't the kind of, these aren't the kinds of cases where you can take a really hardline position and just say, oh, well, we're just taking a hardline position. The court is actually going to punish you for doing that if, this poor employee has been wounded by that particular action. The awards are generally increasing, so it is something to be concerned about. Just going to our next slide there, I've got a couple of recent damages awards to share with you, just to give you examples of where courts are awarding or not awarding these kinds of damages. The first one is Russell in the Brick Warehouse. So this is a case out of the Ontario Supreme Court. And in this, the kind of wrongdoing by the defendant included a poorly drafted termination letter, a miscalculation of the Employment Standards Act minimum requirements, a failure to pay the employment standard minimums for 7.5 months, and in a situation where there was no allegation of cause. So there was no reason why this money could not have been paid and should not have been paid right away. Another piece was that the employer didn't actually tell the employee that his benefits had been in fact continued. So the poor employee was sitting there thinking he didn't have any benefits, but he actually did. So in sort of sum total, those things justified aggravated, but not punitive damages. The thing that I thought was really interesting about this case was the language of the termination letter. So it looked fairly standard, but the real place where the employer went wrong is they didn't highlight in the termination letter, which was, a standard letter that offered a sort of common law amount of notice in exchange for a release. And they didn't highlight in the letter that even if the employee didn't accept the common law amount, they would still get the employment standards minimums. And the court found that that was unduly misleading. That was an insensitive and kind of misleading position to take. And so when combined with the fact that through a bunch of administrative errors, they didn't end up paying the ESA minimums for 7.5 months, that did justify an award of aggravated damages. And frankly, the administrative back and forth about these damages, it was like a comedy of errors. The employer would send the amount, but it wouldn't be quite right. So the employee would refuse it and send it back. And that literally went back and forth for 7.5 months. And the court basically just said, employer, that's your responsibility. You figure out how much it is and make sure it gets to the employee. So kind of an interesting one. The second case is LEHR and Patel Pharma. That's on the complete other side where there was no award of aggravated or punitive damages. And this one was sort of an interesting one because the employer had actually asked the employee if they wanted to resign. And the employee, because the employee had kind of, implied that they were maybe wanting to resign. But the employee decided not to. And then about a week later, the employer decided to terminate. I don't think that could have been too much of a surprise if the employer is asking for your resignation. It doesn't seem to be too surprising that you might then later get terminated. But the argument by counsel was that the employer should have prepared the employee in some way for the fact that she could be terminated. That didn't have a lot of purchase with the court. And then the other thing that happened in this particular case is the employer gave the employee a neutral reference. So a fair reference, one that was apparently justified based on her performance, but one that was not particularly glowing. And the employee, did not get the job that she had applied for once the employer gave this kind of neutral reference. And in all those circumstances, the court said, no, this is not an aggravated or punitive damages case. We're not going to punish the employer for these kinds of behaviors. Now, our last slide on kind of recent damages awards, I've highlighted here, this is on the other extreme end. This is on the, it's almost like those little bears that have the porridge that's like, too hot, too cold, and just right. So we had, the kind of medium case. We had the, no aggravated damages. This is the one where the court just went, good grief, this is terrible. aggravated and punitive damages awarded. And the facts on this were quite extreme. The employer in the case really set this employee up to fail. They were verbally abusive. The string of expletives in the case is pretty impressive. They lied to her about the reasons for her dismissal. They spoke to other people, including clients and other employees, and basically let them know she was going to be terminated before that even happened. And so that all kind of happened in and around the dismissal. And then, they went really into sort of troublesome ground when they had their litigation strategy as well. They had initially alleged cause, and then did not amend their pleadings, even though they decided to completely abandon the cause argument. So, this employee was left with, a notice of civil claim that essentially said she was a terrible employee and a bad person and all sorts of other things. But that actually wasn't even what was argued at trial. And so the court was really unimpressed by that. And then even once they got to the trial, at that point, it was really clear that cause was not at issue. So this employee's performance was essentially irrelevant to the case. And yet the employer decided to lead all kinds of unnecessary evidence about her performance, even going into her personal life. There was literally evidence about who she was dating and why that just showed that she was a terrible person and made bad decisions and was an awful employee. Also didn't help that throughout the litigation, it looked very, the document disclosure, there's a lot of sort of suspicion around that. And it looked like the employer had either hid or destroyed clearly relevant documents. So on the whole, all of that behavior not to be awarded by, not to be kind of not to be allowed to proceed without sanction, I guess is how I'd frame it. And of course, this had a terrible impact on the employee. So it was easy for her to show the impact that had on her. She ended up with $50,000 worth of aggravated damages, and then also a $25,000 award for punitive damages. And frankly, I would almost argue that the punitive damages was a little bit low in that particular case, given what happened in the case. So there we go. That is your update on 2021 kind of bad faith and bad behavior cases. And I'll turn it over to Maria for damages for lost opportunity.
Thanks, Elizabeth. So as Elizabeth mentioned, so this case that I'd like to talk about came out of the British Columbia, the BC Court of Appeal earlier this year. And it's a reminder that additional damages can be awarded for lost opportunity. And in this particular case, it's where a dismissal deprives an employee of an opportunity they would have had, but for the wrongful dismissal. The facts are super interesting. It's not often that we see articling students as plaintiffs in cases that make it all the way to the Court of Appeal. So in this case, it was an articling student who had completed 4 months of her articles, and she was terminated for cause. Ultimately, the employer was found both at the trial level and at the Court of Appeal level to have made unfounded allegations of plagiarism and disclosure of confidential information. So cause particularly wasn't the issue. The importance of this case really does come down to the damages. So at trial, as I mentioned, cause was not found, and it was found that she could be awarded damages for breach of contract and aggravated damages. And I put those up on the slide there. So you can see she got around $18,000 and change around general damages and $50,000 for aggravated. But the plaintiff did cross appeal, and she did seek additional damages for lost opportunity and punitive damages as well, in addition to the damages that she was awarded at trial. And the BC Court of Appeal agreed with her. They ultimately awarded her $100,000 extra of general damages purely attributed to lost opportunity damages. They reiterated that, normally wrongful dismissal cases are focusing on notice damages. But in her case, her termination that was improperly for cause had delayed her completion of her articles by a year. It greatly diminished her earning potential, said the court, and it also delayed her call to the bar. And I think the factual basis for this award really was the fact that her inability to earn a lawyer's income was due to the employer's breach of contract, and that was not reasonably foreseeable to her at the time that the contract was formed. In terms of evidence, this case was tricky. The court did look at her positive performance reviews and evidence that her salary would increase upon the completion of her articles once she was admitted to the bar. So that's what the court discussed quite a bit. But this case really, again, it's an important reminder that these lost opportunity damages can be staggering they can have a significant impact on awards. And it's, in this case in particular, was a big difference from the trial level. So as you can see, as I mentioned, $100,000 in lost opportunity damages. She had $50,000 aggravated that remained from trial, and the plaintiff was also awarded $25,000 in punitive damages. The takeaway here would be that a loss of opportunity claim really can result in liability that far exceeds what an employer may have to pay an employee if the contract were lawfully terminated. So giving proper notice or just waiting until the end. And while this decision did focus on an articling student's experience, its general principles on damages, on lost opportunity damages, and the damage award itself makes it an important decision for all employers, no matter which province you're in. Okay, and I will also give us an update on case law that have come out over the last year on the duty to mitigate. And I see that we're where we are for time, so I will just give you guys the highlights. In terms of the duty to mitigate, employees, as we know, have a legal duty to take reasonable steps to pursue alternative comparable employment, and if that employment is available, to accept such employment. And the principle really from a damages perspective is that they will be reduced or denied by a court where an employer can prove that an employee has failed to mitigate their losses. And the first decision that I wanted to highlight was Lake and LaPresse, 2018, out of Ontario. In this case, the facts are not controversial. We had a without cause termination, a 52-year-old employee, a woman. She was a general manager at a newspaper, and she had just over 5.5 years of service. And the key here was that 2 years following the termination, she still did not have a job. The court found that her reasonable notice period was 8 months, but they accepted the employer's argument that there should be a reduction in the notice period, and they reduced her notice period from 8 months to 6 months. The commentary was quite clear. The court, in so many words, said she did too little, too late. The court saw the clock run on her duty to mitigate right after her last day of employment. She was given 1 month notice, and they figured that this first day after she had finished her job, she was eligible and should have gone out and started applying jobs then, or at least taken steps to move towards that. She did take advantage of career counseling services, which are something that we see courts look at when they're assessing mitigation efforts, but they didn't happen until a couple of months after she was unemployed. Ultimately, she also applied for too few jobs. She applied for 11 overall by the time they got to trial, but only 7 were applied within the notice period. And the last factor was that she just aimed too high, unfortunately. The jobs that she did apply to were vice president positions, which there was no evidence to suggest she would have gotten. So this is an important case. As you know, it reiterates a general duty to mitigate, but it also gives us a sense of what the courts will be looking at in terms of timing around that duty. And this next case is Nahum and Honeycomb Hospitality, also Ontario. This is, again, another good reminder that while there is a duty to mitigate, every employee will be different, and every employee's experience and process through that mitigation, those mitigation efforts will look different. We have a 28-year-old woman who was terminated without cause. She was 5 months pregnant. And interestingly, she only had 4.5 months service. So this is a very short service employee. She was still unemployed, at the time of trial. She had applied to approximately 36 jobs before her baby had been born. And she had a brief 2-month period after her baby was born before she resumed her job search efforts again. And ultimately, she was asking for 8 months notice. The employer, on the other hand, said that she was entitled to 2 months notice. And they were quoted in the decision as noting that that was a generous notice period. So the sole issue at this case really was the impact, if any, that her pregnancy had had on her reasonable notice calculation. Ultimately, the court did award in her favor. They got closer to her notice period at the 5-month period. The court reiterated that pregnancy must be considered in determining a notice period, but it will not automatically lengthen the notice period in every case. But it did in this case, and it can increase time that it takes to find similar employment depending on the industry. The court also didn't really buy the employer's generous characterization of their 2 months notice, as it didn't account for how long and how far along she was into her pregnancy. So aside from the impact that pregnancy can have on the notice period, it is important to consider factors like this, individualized factors to the employee, but also just pregnancy in general, the impact that it can have on finding comparable employment. And obviously, this is also a case that reminds employers to be mindful of other legal issues that may arise when terminating any employee who is pregnant.
Hey, I think that's over to me. Just an update on the Waxdale case. If you were kind of following things from last year, this is the case where the Ontario Court of Appeal said that you have to read termination clauses in an employment contract as a whole. And the invalidity of one of those clauses is going to result in the invalidity of all of them. So in particular, if you have a perfectly valid clause limiting common law notice that's payable on a without cause termination, but your for cause termination clause is contrary to the employment standards legislation, then both clauses are going to fail. Now, unfortunately, many contracts have a Waxdale problem, and that's because, in Ontario in particular, because under the Ontario Employment Standards legislation, you can only terminate without employment standards notice if the employee has engaged in willful misconduct, disobedience, or willful neglect of duty that's not trivial and has not been condoned. Now, many contracts refer to just cause at common law, which is at least arguably a lower standard than that required by the Employment Standards Act, essentially because it makes it easier to terminate. And the implication is it's easier to terminate without having to provide any kind of notice. So the other kind of contract that has now become a problem after Waxdale are contracts that can specify situations that constitute just cause. For example, like a substantial breach of the employment agreement, activities that bring the employer into disrepute, et cetera. And again, usually because they make it easier to terminate than it is under the Employment Standards Act. So as a result, because these set kind of a lesser standard or provide a lesser standard for termination, it's a lesser benefit to the employee, and it's contrary to the Employment Standards Act. So then that for cause termination provision is unenforceable. Now, the kind of extra part from Waxdale is that the courts say, well, we can't sort of separate out termination clauses. So if you've got one of these unenforceable for cause termination clauses, your otherwise enforceable without cause termination clauses are going to get thrown out as well. And so as a result, plaintiffs are being awarded common law notice, even though they agreed to accept considerably less under their contracts. Now, the Supreme Court of Canada didn't want to hear the appeal from Waxdale. An appeal from Waxdale, leave to appeal to the SCC was denied in January of 2021. And so Waxdale stands as the law in Ontario at this time. And we're seeing it being applied regularly. There were a number of blog posts when the case kind of first came down saying, oh, don't worry, it's not so bad. We'll be able to distinguish it. But right now, of the 6 cases that had a Waxdale problem this year, 5 of them found for the plaintiff, and the plaintiff ended up walking away with a bunch of money that, absent Waxdale, they would not have expected. Turning to our next slide, the kind of one beacon of hope for employer counsel and employers is the Raman and Cannon Design Architecture case. That's the one case in which they actually found for the defense. Kind of an interesting case because, based on the bare facts, you would think that this was a Waxdale problem that was going to be resolved in favor of the plaintiff. It had the same kind of termination language, and it had the same kinds of sort of saving language. And don't worry, we do want to meet the ESA standards, that we see in some of the other cases that weren't working in those cases. And yet we end up with a different result. So, how did the court distinguish Waxdale? Well, essentially, they said on the facts of this particular case, there was a clear mutual intent to comply with the minimum standards of the ESA. And essentially, what they looked at was the fact that in this case, the parties both had counsel. There was a lengthy period of negotiation. And in the kind of written correspondence that took place as part of the negotiation process, they actually talked about the ESA termination requirements generally. They didn't talk about for-cause termination, but they talked about without-cause termination. And, everybody was in agreement that, okay, we can't contract out of the employment standards minimums. And so even though ultimately in their contract, the employees used what in other cases was found to be, the common law just cause lower standard for termination. That couldn't have possibly been what they meant, given the context in which the language was negotiated. So essentially, the court said, well, even though this says, just refers to the common law notice, they clearly meant that it should be interpreted in compliance with the Employment Standards Act. It was a big win for Canon, as Ms. Rahman was limited to receiving the notice that she had negotiated, and quite a disappointment, I think, for Ms. Rahman. Now, a couple of things, if you're sitting there going, oh dear, do I have to worry about this? This is only a problem in jurisdictions that define just cause. So, for example, here in BC, where I practice, it's not an issue because we don't have a definition of just cause that's different from the common law at all. So the kind of takeaway there for this one is really look at your employment contracts, particularly if you're in Ontario, and do make sure that those get revised so that you don't end up on the wrong end of a Waxdale problem. Now, I will turn it over to Magali to talk about severance and give you a little update on that front.
Thanks, Elizabeth. I'll be speaking to this one here. So we have a brief little update on service and severance. So that's a length of service and the impact that it could have on severance of employment, particularly as it relates to common law entitlements. So in this circumstances, what's important to consider is employees will sometimes return to a former employer after resigning, perhaps to accept new employment. And when there is a long gap in service, the rehiring employer will often treat the returning employee as a new employee for all purposes, including calculating their severance payments. Courts will consider a variety of factors in deciding what impact that break in service will have on length of service for common law entitlements. First, of course, looking at the employment contract, but there are a number of different factors. And the case that I want to highlight today is Hetherington and Saskatchewan Liquor and Gaming Authority. So it's a public sector case, and it's a Saskatchewan decision. This case does a really great job of reviewing the types of factors that are looked at in terms of these common law entitlements. It's a decision where, again, relatively uncomplicated facts. We have a public sector employee with 28 years of service, 2-year gap in service where she took a job with another employer, but otherwise had been there for 28 years. Her position was eliminated, and her severance package was based solely on her most recent uninterrupted years of service with the government. And she sued and asked the court for a severance package based on her full 28 years of service. So again, the key issue here was really what did that 2-year gap, how did that 2-year gap impact what her severance entitlements would have been under the common law? So the court reviewed the number of factors that they reviewed the number of factors that are important to them, not just in Saskatchewan, but these are factors that are considered across Canada. So first they'll look at the employment contract. Was that determinative? In this case, they didn't find that it was. They found that there was no guidance in the contract to lead them one way or the other in terms of how to recognize her prior service. But they did look at things like the fact that she voluntarily left her position. She was not induced to return to position by the employer. Her full years of service, 28 years, were recognized in things like her pension plan, her other benefits, her vacation entitlements. All of these things together led the court to decide that her full 28 years of service needed to be recognized when it came to her severance payment when she was terminated. So as I said, these are factors that are looked at not just in Saskatchewan, so it's an important decision for employers across Canada. And it's also just a good reminder to take a look at your employment agreements, see what types of provisions are in there that would lead a court or perhaps an employee to recognizing prior service one way or another, depending on the entitlement at issue. And I believe I'm passing it over to Magali now to talk about equal wages.
Thanks, Maria-Cristina. So just very briefly, I'll talk about a Quebec Court of Appeal decision rendered earlier this year that upheld a decision of the Human Rights Tribunal, which had ordered the Aluminerie de Bécancour to pay the victims damages for injury to their dignity. And basically, these victims were students that had worked mainly in the summer season for the Aluminerie de Bécancour. The Human Rights Commission had brought forward an application against the employer, arguing that the students, who are the lowest paid of all the employees at the company, and that their difference in that salary was only justified by the employer because of their age and social condition, which are both prohibited grounds of discrimination under the Quebec Human Rights Charter. And so the commission went on to sue before the tribunal the company. This situation had been lasting for many, many years, went far back as far as 1995, when student wages were decreased to a percentage of 85% of the lowest wage index of the company. And this reduction in salary for students had been maintained in subsequent collective agreements and their subsequent renewals. So the commission, when the investigation happened and when the commission brought forward this suit against the company, their position was that the students were the lowest paid of all the employees and that the difference in salary was only justified by the employer on the mere fact of their age and their social condition, the fact that they were students. And the commission was also taking the position that the work that they were performing was exactly the same as the other employees that were receiving a higher salary. And so one of the issues was whether the fact that a person is a student is part of what we call the social condition, which is really the grounds, prohibited grounds of discrimination recognized by the Human Rights Charter. And when the in the analysis of the tribunal, which is upheld by the Quebec court, they did consider that the fact of being a student is part of a social group to which the society attributes certain stereotypes. And it is because of that status that the students did not get the equal treatment for the equivalent work. So there was also an analysis done by the tribunal in terms of to establish that the work performed by the students was not different, and that this difference in remuneration could not have been relied upon because of any different tasks that were being performed by the various categories of employees, students versus non-students. And based on that, the court concluded that there was no reason for the company to pay students a lower wage for equivalent work. The students had suffered moral prejudice, have been victims of an injustice, according to the tribunal, and that attack in their dignity justified an award of $1,000 for each of the students involved in that recourse. So there was also a finding, because the employer had alleged that the union, who had repeatedly renewed the collective agreement from year to year, that they should have been was condemnation, basically, that this was acceptable, but that argument was set aside by both the tribunal and the Court of Appeal. So the key lesson for employers is that if the work being performed by various categories of employees, such as students, is exactly the same, and there cannot be an argument based on the difference in the tasks performed, then the wages must be the same for all categories of employees. And if not, then the social condition or the status of being a student can be invoked against as being grounds of discrimination. So we are now at the question session, and I will pass it on to Maria-Cristina, who will take over on that topic. Thanks.
Thank you. And thanks everyone for sending in your questions. No surprise, we have a lot of questions around mandatory vaccination and COVID, so I will start with some of those. So first, I'll throw it out to the group. Should an employer, or does an employer need to provide a deadline by which their employees must get vaccinated?
I'm happy to jump in there. I think it depends on what you're trying to achieve with your policy. If ultimately there's going to be consequences for employees that fail to be fully vaccinated, so whether that be an unpaid suspension or a termination or something of that sort, then I think you do need to have a deadline. Employees need to know by what time they need to be fully vaccinated. And when you're incorporating that deadline, you want to allow enough time so that employees that aren't vaccinated have the opportunity to become vaccinated. If, however, your policy is simply a suggestion that employees get vaccinated and there's not going to be consequences for their failure to do so, then you don't need to have a deadline. So it really does depend on what you're trying to achieve with your policy.
And so how does the issue of terminating for failing to abide by a mandatory vaccination policy factor into the issue of constructive dismissal? This is something that we're seeing everyone that's a hot button issue right now. Everyone sort of wants to know what the threshold could be, how the courts may look at it. I'll throw it out to the panel as well. On the issue of constructive dismissal, how could it possibly apply in a case like this?
Well, I'll start with that too, but I'm very interested to hear folks' comments from the other provinces as well. So first of all, if you are actually terminating people, it will be a wrongful dismissal matter, not necessarily a constructive dismissal matter. But before you get to that termination, you're quite right. We will see people claiming that it is a change in a fundamental term or condition of their employment, and therefore constitutes a constructive dismissal, which allows them to quit and claim the same damages they would have received had they been terminated without cause. Whether it actually will be a constructive dismissal, I think will depend on the workplace. There may be workplaces, for example, thinking of healthcare situations, particularly in those jurisdictions where there is a vaccine mandate from a government, or thinking about the airlines, for example, where there is a government suggestion or mandate for employees to be vaccinated. There, that may give some employers some cover, and there it may not be a constructive dismissal. If it's a situation like us, for example, lawyers, even though we're not employees, but or many of us aren't, where we've been working from home just fine, frankly, for 2 years, and all of a sudden now there's a requirement to be fully vaccinated and to attend in the office, that may very well be a constructive dismissal. And whether it is or not, I think it's going to depend on the court that hears the matter.
I will add to that, Karen, that I think we're now at a stage where employers have a right to say this, working from home is enough, and the population is largely vaccinated, and we think that it's within management right to be asking people to come back to work. And that perspective, an unvaccinated employee that is being asked to return to work has to be protected. It's health and safety, his own, her own, and also the ones of his peers has to be protected. And if we look at it from that perspective, is it really a substantial change in the condition of employment to impose vaccination if that requirement is basically just a basic requirement of protecting the employee's health and safety? Just like we would want to say to that employee, we've changed your desk, or we've changed your area of work, or we've changed the machine on which you were working because it wasn't safe. And now we're imposing new procedures or new protocols because we want to make sure we're able to abide by those obligations. So I think we could use that argument to put it aside. But the initial question is the one that you raised, is it within an employer's right at this stage of where COVID is to say to its employees, we want you back? And does the employer have to accept that somebody who is not vaccinated may say, oh, well, I don't want to be vaccinated and I want to continue working from home, where all his other colleagues have to return to work? It would become, the result would be that that person would have an advantage that the others are not getting, for those who want to stay home and work from home. So I think the initial first step is whether the employer is imposing a return to work that is a reasonable decision, that is within the management right, that gives reasonable notice to employees to take precautions or organize their either schedule with kids and all of that to be able to reorganize going back to work. But after that, I think it's safe to think that we have good arguments to counter a claim for constructive dismissal on that perspective.
Yeah, that's a very good point.
I would add that the same kind of applies out here in British Columbia. We've got some, if anyone ever needs it, we have some delightful language from Madam Justice Southern about the scope of employers' rights. And she basically says, look, that's the employer's workplace. They get to say what happens, and as long as it's lawful and not degrading, then essentially you just have to listen, employees. It's quite strong language, and I think in the context of this pandemic, the argument is, well, it's not actually, there's no change. The employer has always had the right to direct the workforce and to make these decisions within the workforce. So I think that's the tack that a lot of employers will end up taking to kind of justify these decisions. And I think it'll be very interesting to see what the courts do with that. You can imagine just kind of knowing, the members of the bench tend to be a little older, they're at high risk. They might be pretty sympathetic to arguments that, we need to get people vaccinated and to encourage that for, both public policy kind of reasons as well as, within the workplace. So.
And so is there any, just along that same line, Elizabeth, and I suppose to the entire panel as well, in addition to putting out a policy on mandatory vaccination, would you recommend any amendments to existing employment agreements? Or as you said, this is sort of baked into the health and safety obligations of the employer. Is there any other sort of changes that employers should be aware of?
Well, I think you're certainly in an easier position with new employees. Always, of course, subject to accommodation for people who can't get vaccinated for protected reasons that are protected under the human rights codes. But yeah, you're in for new employees. I think if people want to look at putting those a requirement to be vaccinated into the contract, and again subject to those human rights concerns, I think you're in an easier position than this sort of arguable change for your existing employees. So I think that's are practically speaking, are people going to go back and kind of make full-on contractual changes for all their current employees? I haven't seen employers looking to do that, but I've had a lot of people asking about, okay, what about new employees?
I've had the same experience as Elizabeth. I agree with her comments.
When it comes to unpaid leaves of absences, so if we're putting employees on unpaid leaves of absences for failing to abide by or be vaccinated by a particular date, are there any concerns that an employer should be aware of, perhaps from the perspective of could that possibly be considered a layoff? How long should these employees be on leaves of absences? Does it depend on the position? What are some of the concerns around that? I suppose from across the country, but yeah, sorry, Magali.
Yeah, I was going to say it's a very good question. I mean, I sort of see it as an invention of employers to be reasonable and to act in between the ultimate, which would be terminating the employees. And by that message, they're telling the employees, look, unfortunately, we can't have you come back to work because our condition is, one, you have to come back to work, and number two, or when I say back to work, is back within the premises of the company, or you have to serve clients in person again, and number two, the requirement is that you have to be vaccinated, and because you chose not to be vaccinated, unfortunately, we can't have you come back, and therefore, instead of terminating your employment, we're prepared to rehire you at any time where you get vaccinated, and this is why we're keeping the employment relationship intact. Is it a layoff? It's not a layoff. I don't see it that way from a perspective of our Labor Standards Act in Quebec, which usually or typically would be due to restructuring, economic reasons. So I would have an issue here to see it that way. And the way I've dealt with it is employers that do put employees on a unpaid leave of absence should tell them that this will stay as long as it's possible for them to keep the employment relationship. Just like I gave earlier as an example, if at any point in time you need to replace by a permanent hire that employee, and I mean, maybe then you will have to take the decision to terminate that employee because you need to rehire somebody in lieu or instead of that person. And when doing or taking that decision, I think, again, the employer has to take a reasonable approach, has to see whether a temporary hire was possible or not. And when it's not possible, then the employer could come back to the employee, tell them that the unpaid leave of absence is no longer that, but now is a dismissal. So any letter confirming that status to the employee should also know that this is temporary and could be changed in the future.
And we have a final question here on, we have lots of interest on remote work, on Elizabeth's comments on remote work and a lot of the jurisdictional questions that are coming up. So one of the things that I'm seeing more often here is, should employers always consider the legislation of the location where the worker has relocated to, if out of the province that they were originally hired in? Should the employers be considering the new legislation and the original legislation, health and safety issues in the new jurisdiction or in the old jurisdiction? What are some of the concerns around that?
Well, I think the key thing is the vast majority of employment standards kind of legislation, certainly at least within Canada, if you're looking at provincially regulated employees, they're really based where the worker is. Most jurisdictions, they kind of deal with people who are just moving for a temporary kind of situation. Like if you're going to if I go to a conference in Alberta for the weekend or even a week, nobody says, okay, well, now Alberta law applies to you. But I think as soon as you have someone who's in another jurisdiction for an extended period of time, and there's no real case law on this right now, things have kind of been, the pandemic, I think, is, and remote work in the pandemic is really going to be up for consideration, both by legislators and the courts as we kind of figure these things out. So I'm not aware of any specific cases that have said kind of in the context of COVID-19, if you're gone for, 3 months into another province, that's when it, kind of kicks over. I think just sort of my gut reaction is, if you're going to be longer in the other province, that working from that other province, certainly on a permanent basis, then obviously you're going to need to look at the jurisdiction of where that employee is now that they're permanently there. And if they're kind of, I would use as a guideline, I would start to think about it if they're going to be there for more than kind of, a lengthy holiday time. So I would sort of put that in. If they're going to be working from that other jurisdiction for more than a month or two, you need to start thinking about, okay, do we have some risk here? And you may be prepared to take that risk. Some employers are, but I think it is important to start thinking about that when you've got that amount of time.
That's great. Thank you so much, everyone, for your questions, and to this wonderful panel for your answers. I'm going to pass it along to Karen for some concluding remarks.
Great. Thanks, Maria. And thank you to all of you for joining us today. As I mentioned earlier, our next webinar in this Year in Review series will be next Tuesday, November the 16th, and it will be on human rights. So I'm sure that COVID will come up there too. If you have any questions about any of these matters, feel free to visit our website, fasken.com, to register for the seminar or refer to our materials. And as I said before, thanks again.